move. We've got 117 participants so far, so I'm hoping everyone will enjoy the next discussion that we have. Good morning, everyone. Thanks so much for joining our webinar this morning. It's wonderful to have you with us. I'm delighted to be joined by my colleague and friend, Marisha, as we unpack the new Code of Good Practice on dismissal. Given the time constraints, we won't be dealing in detail in relation to the items, but we'll do an overview in relation to the code. As we were preparing for today, we decided to keep the session quite conversational, so please feel free to share any questions in the Q&A. We will do our best to address them toward the end of our discussion. We hope you enjoy spending time with us this morning.
Thank you, Heads. Thank you so much. Good morning, everybody. Like Heda said, this morning we're going to be looking at the new Code of Good Practice on dismissal. It's a look at it at a glance. So like Heda said, we won't be going into the detail. But Heda, perhaps you could start by telling us what is the current legal status of the Code of Good Practice under the LRA?
Well, I have to deal with a little bit of the dry aspect of this. So we'll have to go back to 1995. As we know, the LRA was introduced and promulgated in 1995, and of specific reference in relation to what we're discussing today is Section 203, which empowered NEDLAC to issue codes of good practice. Section 203.3 required that anyone applying the code must take into account any relevant code. You'll see the reason why I'm emphasizing the word must, because over time there were obviously changes. Things started to progress in terms of our law, and significantly in 2002 there was an introduction to subsection 203.4, which was added to section 203, allowing codes to stipulate that they must be taken into account when interpreting or applying employment law. This created some tension between subsection 203.3 and 4. One seemed to make all codes mandatory to consider, whilst the other limited that obligation to the code when the code specifically said you must take the code into consideration. So now with the 2025 code, it's not stating that it must be taken into account. Like the earlier Schedule 8 code, it's a guide, and that's what we must remember today, ladies and gentlemen. It is merely a guide, but the fact of the matter is, even if we're saying it's a guide, the case law as far back as 1997 had said if you ignore a code, you're ignoring it at your own peril.
Of course.
So we have the guide. Let's use the guide. That's the reason why we have the guide in front of us, and it's basically giving you the tools on how to conduct your processes both substantively and procedurally fair.
Yes, I think a lot of people assume that the code is binding like legislation, and it's like you said, it's just a guide, and it's done it's not legalese, so it's easy for HR people and business owners to easily identify with what the requirements are and to follow them. I think ignoring the code doesn't essentially break the law, but it can make you look reckless if you are ever in a dispute at the CCMA or in the labor court. So it's not about ticking boxes, it's about showing that your process reflects fairness, as explained in the code.
And as I said, why reinvent the wheel? You have it there, it's giving you the guide. So whilst we're on that end, what is the nature and the purpose of the code?
So it bridges the gap between the Constitution's right to fair labor practice and real workplace management, right? It serves as a set of guidelines or best practice standards distilled from judicial interpretation of the LRA, essentially. And it helps apply the Act's general provisions, such as Section 188 on unfair dismissals in real workplace situations. But every HR practitioner should be considering it when dealing with discipline and dismissals in the workplace. It is a very useful tool.
And the Constitution, what role does that play?
So the Constitution's right to fair labor practices remain the same. It's essentially the code connects the constitutional right to fair labor practices with practical labor standards under the LRA.
So could we then say that the new 2025 code is simply restating existing law, or what would you say?
Not entirely. I think while much of the code codifies established jurisprudence, the 2025 code introduces new ideas. I think the code is modern. Practical, modern difficulties that workplaces experience are now dealt with, especially for small businesses. It moves beyond existing case law, particularly for small businesses.
And that is obviously the significant change, and a lot of people have sort of gotten stuck onto the fact that it now introduces or specifically refers to small businesses. And whilst we're at that, I'm going to deal with the significance of that because it reflects international trends. Whilst we haven't ratified the convention, our ILO 158 convention, it has been used as a guide. And strangely enough, if I can use the word strangely enough, as far back as 2011, we had Halton Cheadle already writing a white paper in relation to small businesses, and that there should be more flexibility, there should be more relaxation in relation to the small businesses. And that is now finally in 2025, almost, what is it, 12, 13 years later, after the esteemed Halton and Cheadle had already mentioned this and made reference to this in 2011, as well as the ILL convention that says that small businesses can't be the same.
So it's not a one size fits
No,
all.
it cannot be a template where you're just ticking a box and everybody has to comply with that box. And if you haven't complied with the box, well, then you fail potentially both on the procedural and the substantive fairness of it.
Of course. I mean, I think this is one of the biggest shifts, recognizing that small businesses can't run disciplinary hearings like multinationals. I think the principle is flexibility with accountability, essentially. You can simplify the process, but fairness would still apply. So if you're a 10-person firm, a conversation and written note, may be enough. But if you're a listed company, then skipping formal hearings could be risky.
Absolutely.
I think, the absence of a clear definition of a small business is critical here. A company with 40 employees but no HR department, is that a small business? Maybe you can tell us a little bit about that. What are the key principles for small businesses under item 3?
So in terms of item 3, it doesn't define, or the code in itself doesn't define small businesses. And I think that's been deliberately done because, as you had already alluded to, it can't be a one size fits all.
Yeah.
So small businesses are not expected to comply with obligations that are impractical or infeasible in terms of the new code. Fairness must be assessed considering their operating circumstances, and examples of this include the limited capacity to conduct, for example, lengthy investigations, because they don't have a fully fledged HR department. As you and I both know, and many of our clients, they will be small businesses. You will have one person who attends to various functions within that business and does not have the capacity. I'm not suggesting for a moment they don't have the ability, but it's more of a capacity aspect and an operational aspect as to whether or not I can spend 3-4 days now investigating what the misconduct that I'm going to allege that you have conducted yourself, or I'm suggesting you've committed. So in that sense, that is what the code and where you're using the word is becoming more modern, is that it is recognizing that there are going to be operational challenges in relation to small businesses. But if there's any key takeaway, ladies and gentlemen, from today, just because you are a small business does not mean that you don't comply.
Yes.
Does not mean that you do away and you simply call Militia into a meeting and say, Militia, you no longer fit the model, or we found you guilty of X and you are therefore dismissed. There has to still be a process, but we'll obviously get into that a little bit later.
Well, of course, there has to be a process, but surely there must be factors that determine what a small business must do in this situation. Does the code address that?
So the code does specifically deal with that, because it even makes reference to the fact whether or not the business has a formal HR department or not. So as I'd already said, now you'll have Bob who's attending to all of it.
Yeah.
So he may not have the capacity to deal with it, whether that complex procedure may disrupt the operation. So for example, if you have a massive investigation that you now have to conduct and the entire business is now involved for some minor infraction, why would you do that?
Yeah.
In the sense where you're pulling everybody out of the business to now focus on this inquiry to try and get it over the line, that you've now ensured that you procedurally and substantively cleared those boxes and made sure that the fairness aspect of our law is adhered to. So ultimately, the scale and the commercial realities, my apologies, of the enterprise is what is also going to then be taken into account. And as we know, our law is forever changing. Our case law changes, the themes change, the value systems within that change as well. It all depends on the judge who's hearing the matter. His or her impact on that outcome is massive, and we can't underestimate that. And case law takes time to settle. We've seen it throughout the years from 1995, obviously, till now, how our case law has ebbed and flowed, and where we then are comfortable to say, well, in terms of X perspective of our law, let's take section 197, for example, for now, we seem to have settled that aspect. And the same is going to then apply in relation to the interpretation of the code, and obviously how people then will want to circumvent, and I'm being quite nice when I use the word circumvent, the aspects and the obligations that are still on all of us, irrespective of large or small.
Well, I think that's something that we need to go into, because essentially the principle of Audi still applies. Where you have to give the employee an opportunity to respond. It doesn't, the new code doesn't relax the principles of substantive and procedural fairness as I read it.
Correct. So whilst we're on the fair procedure, and we know from the code that this is specifically dealt with in item 11, if you could just share with our viewers today, what is the item 11, and what does it say about fair procedure?
So item 11 of the code emphasizes that fairness requires genuine dialogue. That's the new introduction of the words genuine dialogue in our code. And that just simply means that you must engage with your employees if there's a problem. It's something that we've been doing all along anyway, or you should have been doing as business owners and as HR managers. You should be engaging with your employees if there is a problem. So item 11 basically just introduces it as a guideline now. Genuine dialogue is necessary. And item 11.4 also adds the right to notice, representation, and response, but that's always been the case.
Okay, nothing new, right?
Nothing new. So you have to give the employee an opportunity to respond to whatever notice, obviously, of the allegations against them, and an opportunity to respond. How you give them that opportunity to respond, whether it is through written submissions or verbal responses, or in a hearing, whether it's formal or not formal, it's not defined. And I think that's the takeaway, is that as long as those things apply, you give them notice, there is representation, and they are given an opportunity to respond to the allegations, then you have complied with the fairness obligation in the code.
And again, therein, the one size fits all is not going to be applicable, because in certain instances you would be able to simply deal with the matter by way of written submissions. Let's take the example that we had discussed earlier in our preparation from a gross negligence perspective. If I have a paper trail as the employer where I've raised various issues, the gross negligence is pretty obvious or straightforward in terms of the evidence that we have available. Why could we then not just simply issue the notification, set out in the notice why we believe that you are grossly negligent, and for whatever reason we determine that this has now potentially irretrievably broken down the employment relationship, give us reasons as to why you should not be dismissed. But again, that can't be a one size fits all where you're only dealing with written submissions, because it depends.
You could have a case where the employee is has allegedly committed a fraud. That's very different to a minor transgression. So the code re-emphasizes dialogue, and it's not only about the paperwork, if I can call it that. It's moving away from the criminal style of hearings where there is cross-examination and re-examination, and it's overly formalistic. I think the takeaway here is to keep it simple, keep it fair, and keep records. If you have a situation where you have an employee who has committed a serious misconduct, it requires investigation. Obviously, there must be more formal procedures that you would follow. But essentially, as long as you give the person an opportunity to respond, you have complied essentially with the provisions of the code.
And I mean, having said that, we all have the employees who will deny everything. So you may not be in that instance be able to do this by written submissions, because if I dispute everything that you are alleging that I've done, you're then going to have to lead some form of evidence in that type of scenario. But it all depends on the nature of the misconduct as to whether or not written submissions would be the appropriate way to go, or whether one has to then give the opportunity to be heard and to deal with it in a more formalistic way, which we become used to. But the point being is that we need to be heard. You need to be given an opportunity to respond to any allegations that your employer poses against you, and taking it from there. So moving on in terms of the code as well, we're dealing with item 20, which relates to incapacity. How does the code now address poor performance in relation to senior employees? Is this anything new, Em?
There is a little bit. I mean, the code now recognizes that senior employees should be self-aware. They need to self-correct they don't need step-by-step warnings. So, the code introduces the concept of incompatibility. It recognizes that as a form of incapacity, essentially. And I think that's an important addition to the code. It's the employee's inability, not unwillingness, to work harmoniously in the workplace. So it's the distinction between can't do and won't do. And employers, I think employers may struggle with this, to classify hybrid situations. Does it fall into incapacity? Does it fall into misconduct? But again, you would have to deal with each case on its own merits. But I do think that the incompatibility aspect being added to incapacity is an important it's an important addition to the code. I think it's practical, I think it's modern, and it happens a lot in workplaces.
I mean, we know simply sometimes you just don't, it's just the wrong fit. That person may have been wonderful in the interview. We think he or she is going to be a wonderful addition to the business, but soon, into the relationship, you realize that this person just doesn't fit within the organization, or is just not able to integrate with the team, or is not a team player, and or doesn't pick up the value system of the company, and it's just simply, there's an inability for him or her to fit in with the corporate culture of that business. And why must the employer then be saddled with that type of person who could potentially create an extremely disharmonious environment, toxic environment, creating politics in the environment? Why?
But
why
not
must
just
we deal with
employees,
that?
though. Not just new employees. I mean, you could have a very talented but abrasive manager that is alienating her team, for example. You could have a situation where the employer treats that as a misconduct, where it actually can be dealt with under incapacity as well. So incompatibility, I think, is one of those additions that is going to create cases.
Right.
And I think that our CCMA and our labor courts are going to have to determine whether it falls under incapacity or whether it is a misconduct. Because it's a behavioral issue in most instances.
A lot of the time. And any other forms of incapacity that have been recognized now?
So in the past, we had incapacity, we had ill health, and we had poor performance. Now the code has introduced this incompatibility, and also imprisonment and addiction, which I think is very important additions to the code. Previously, imprisonment could also be dealt with as a misconduct, but it does incapacitate employees from performing. And addiction as well. I mean, obviously, addiction comes with, it's very similar to the ill health incapacity, in that the employee is incapacitated due to a health problem. So obviously, the way that the employers are going to deal with that is going to be accommodating the employer and all of that. But I think the employee. But I think it's important that it has been included now in the 2025 code as a form of incapacity.
Five times ahead of us, Em.
Yeah, definitely.
So we'll then move on to probation, which has also there's been a nuance in relation to that. The key takeaways that I picked up there, Em, is that now one looks at performance and suitability, as you'd already touched on briefly in relation to incompatibility. There are now fewer hurdles that are required in terms of the probation type process and whether or not you can then terminate. And the big change now is that in probation, you can deal with performance and misconduct, and there's a relaxed standard for fairness during this period. So all, again, depending on the level of the employee in that position, obviously the higher up that person is within the organization, the less mentoring, training, assistance, guidance I as the employer are obligated to give to you. There's obviously, with senior management positions, there's an expectation, and a reasonable one, that I assume when I've hired you that you are able to perform the job at that level. But obviously at the lower end, and I don't think there has been anything significant in relation to that change, you are still going to have to provide the tools in order for that employee to be able to perform at the level that you require that employee to perform at. However, if you need, and my understanding from the code is, if one then unfortunately does not succeed with the probation, again, I think it would simply then mean notification, give the employee the opportunity to respond as to why you don't deem it appropriate for this employee to remain in your employ. Give the employee that opportunity to respond, close it off, and that should be sufficient for purposes of being able to challenge or defend any unfair dismissal dispute that may be referred to the CCMA or bargaining council.
Yeah, look, I think this is a practical win for employers. I've had a lot of queries in my practice about probation and how to deal with problem employees during this period. I think, again, it comes down to a few factors that we've already addressed in the code, such as engaging in genuine dialogue with your new starters, having the check-ins to see whether they are, number one, compatible, with your business, but also you can now look at performance and misconduct, which I think is a win for employers.
Absolutely.
The standard for fairness is a little bit lower, but the code also recognizes that sometimes you realize early that someone just isn't the right fit. So, fairness obviously still means a discussion. It still means feedback, a chance to respond, and all of those things. You can't just terminate an employee cold during probation just because they are on probation. So there is still elements of procedural and substantive fairness, but it would be easier for employers now.
Correct.
And I think that's the takeaway.
And the takeaway again is the dialogue. It's that open engagement with the employee for purposes of that.
And I think that's a theme that runs through the entire code.
Yeah. And whilst we're on the unfortunate position, retrenchments obviously are a reality in our lives. And what are the changes there?
So, there's now item 23.2, which has been introduced, that states that dismissal should be a last resort and used only when no viable alternatives exist after consultation. And I think this section modernizes retrenchments to an extent because it's more about proportionality now. You can't just retrench because it's convenient. I think that was always the case, but now the last resort principle, my interpretation of the last resort principle relates to alternatives that you have considered.
Yes, absolutely.
And that you looked for every other viable alternative. Employers should be doing that already.
Anyway, I mean, Algarax, Oosthuizen, and LAC judgments tell us that.
Exactly. So, I mean, it doesn't make it harder to retrench now. Employers can still retrench for legitimate operational reasons, which includes for profitability and efficiency, but they must first explore all alternatives, document those alternatives if they exist, and then only resort to dismissal if they have exhausted, and looked at every other alternative.
So what we would have to then consider is if an employee comes up with an alternative that could possibly then avoid the job loss, but you as the employer believe that the trajectory that you've now adopted is the way to go, and you need to cut X amount of heads, but this plan that the employee has come up with actually is a viable option. And I mean, Algarax Oosthuizen tells us there's an obligation on you as the employer, and to your point of the last resort reference that is now made in the code, that if that alternative works and avoids the job loss, there's an obligation on the employer then to adopt that.
Of course.
Because the whole purpose of 189, ironically, is to avoid the job loss and to minimize the job losses. So if those alternatives work to obtain your objective, ultimately, whether it's becoming more efficient or more financially sustainable, etc., all of those options are obviously still available to our employers. But the key takeaway here now is if that alternative avoids the job loss and achieves the same outcome, there's no reason why you shouldn't be adopting that.
And I think that's where employers may fall short.
Yeah.
Is that if there is a reasonable alternative suggested that is viable and they don't adopt it and employees get dismissed, then that last resort principle would then come into effect. And I think our CCMA commissioners and possibly Labour Court judges will interpret that as not that the dismissal was not a last resort.
Yeah.
And it could potentially be unfair.
And the consequences of that are reinstatement, starting the process again if one has to.
Yeah.
And given the backlogs in our court, this could be years.
Yeah.
So the the consequences could potentially be quite dire.
But also, I mean, the new code also deals with or introduces this concept of simple retrenchments versus complex retrenchments. Now, we know we have 1893 and we have 189A. I mean, what does this distinction now between simple and complex retrenchments actually mean in the code?
So item 2413 introduces the concept of simple retrenchments by smaller employers, again, not defined, versus large and complex retrenchments. Smaller employers may proceed more quickly, while larger employers must follow lengthier consultation processes. I don't see how that's much different to what we're having now.
I mean, it doesn't replace 189A.
No, not at all. The LRA is still there. The 189A obligations. If it's a large scale retrenchment, the compulsory 60-day period of consultation is still going to exist. That is not falling away. So in terms of the thresholds with 189A, that doesn't fall away. If you fall into those thresholds of the 189A box as contained in the Act, you are obligated to follow what is required of you in terms of that consultation. So it's not replacing the 189A thresholds in LRA at all. It merely supplements them. The code therefore adds a flexible, context-driven distinction, allowing courts to assess fairness based on the employer's size and complexity rather than fixed numerical thresholds. So, but again, 189A, if 189A is applicable, has to be followed. But for the smaller employers, it'll be easier. There's a template even provided in the code, as we've already mentioned in our presentation, which we'll be sharing with everybody after our webinar this morning. There is a template. Again, it's a guide. Use it. It makes things far easier. Make sure that you are complying with the procedural aspects of a retrenchment process, which is already challenging in itself. So, I mean, use the guideline.
It's a tick box. It is a tick box. And I think the simple retrenchments ties in with the small business element addition to the code. You know, it's there to assist small businesses. The Annexure A is your 1893 notice to employees that are affected by possible retrenchments. And I think it's a relief for small employers who need to act quickly. You know, for large employers, the expectation is full consultation, I think, you know, but it's not about size alone. No, I think that's what the takeaway here. It's about complexity, it's about impact, how many people are affected, and how formal the structure is of the business.
No, agreed. Absolutely.
So, I mean, one of the things that you dabble in, and I don't dabble too much in, is strikes. And I think there are some changes in relation to strikes, and it's significant.
Absolutely.
Let me talk us through it.
You'll know from our disciplinary codes, and probably everyone still has it. Generally, the clause has always been, if you participate in an unlawful strike, it's automatic dismissal. Those times have now changed. The changes in relation to the code, it confirms that participation in an unprotected strike does equate to misconduct. However, does not necessarily have to result in an automatic dismissal. So for purposes of that, the employer must therefore assess on a substantive fairness basis, and it can't be a tick box again, ladies and gentlemen, which is based on a listed set of facts which are already included in the code. Again, the guide is there. Seriousness of the contravention. So for example, we have Bob, who's merely standing there. He's not participating in any illegal activity. He's not doing anything wrong. But he's part of it. So by his mere presence there, he's already participating in an unlawful strike. So therefore, the tick box exercise applies. Bob was there, and therefore he must be dismissed. So that is out. There also has to be consideration of whether or not there's been attempts to comply with the LRA, and whether or not the strike, and this is very important, and whether or not the strike is in response to your unlawful conduct as an employer, or that you have created the environment in which the strike is now blown up because you haven't dealt with a grievance, for example. You haven't properly dialogued with people and dealt with their grievances, and you are therefore the purveyor, if I can use that word, for purposes of creating the strike. So these are all factors that courts are going to...
substantive perspective.
Correct.
And procedurally, are there any procedural steps in the code?
I mean, again, everything we should be doing. Union engagement. Try and engage with the unions. Try and see whether you can get the unions to assist. We don't always succeed in that, unfortunately. Often we'll have, because there are many cost orders that are now being, not now, but, where cost orders are being awarded against the unions, you'll often get a case where the union will then totally step back and say, look, we don't support this. So try and engage with them, try and create that solid dialogue relationship with the unions that are inevitably in big, large employers organizations, to be able to have that dialogue with them, to try and organize and to try and bring the strike to an end. Issue clear ultimatums. Often, the experiences that I've had is that the ultimatums are not clear. And while saying that, it doesn't help. And I had this the other day. I was telling you that, for example, at 9:30, the employer then issued the ultimatum and expected everyone to be back 10 minutes later. But you have a workforce of, let's say, 1,000 people.
Then again, not practical.
Not at all. They need to caucus. They need to discuss. They need to understand what the consequences are. I'm not suggesting giving them hours, but I mean, you've got to be reasonable in the time frame that you give them. So that is a significant change in terms of the code.
I think it's a modest change as
It
well.
is.
I
And
think, unprotected strikes shouldn't automatically
no,
result in
I mean,
dismissal.
if it's violent and
Yeah.
there's major destruction and intimidation, that is a completely different
Yeah, yeah.
story. But I mean, if you're talking about work stoppages or go slows, that's not automatically going to then
Yeah.
relate to an automatic dismissal, and you may not be able to defend that.
Yeah. Look, again, it's going to be assessing fairness, right? Because also, was it provoked? Was it short?
There we go.
Was there good faith in the dialogue between the unions and the employer? Potentially, I think the code gives clear steps. Like you said, engage the union, issue ultimatums, and give reflection time. So, it's about cooling things down. It seems to be
That's the
not escalating it.
given the violent nature
Yeah.
of so many of our strikes. Absolutely.
Yeah.
So closing off, what is the overall approach of the 25 code?
So I think that the code promotes flexibility and contextual fairness rather than rigid standards. The new code feels to me more human,
Yeah,
and more modern.
I think that's a good way to put it.
Yeah, it deals with practical elements that we see on a day-to-day basis, and it gives small businesses an opportunity to actually deal with it in their business according to the size of their business and the resources that they have available. It encourages judgment rather than lots and lots of paperwork and cost for businesses, particularly small businesses. For me, the takeaway is that fairness is about substance, not show. The code rewards genuine engagement and not paperwork.
Yeah.
If I can put it that way.
Tick box exercise.
Yeah. The big message, and you would have seen, for our listeners, you would have seen the theme is dialogue, genuine dialogue throughout. Each of the changes that have been made to the code requires dialogue, requires engagement with your people, which I think is right.
Yeah.
And you can avoid a lot of litigation. You can avoid a lot of problem disputes down the line if you just engage meaningfully with your staff.
Or misunderstanding that simply could have been dealt with just with a discussion.
Exactly.
Yeah.
So flexibility, dialogue, and proportionality seem to be the pillars of fairness. And if I can put it this way, for our listeners today, the code is now the GPS. I think
yes, that's a perfect way to put it.
For navigating dismissals.
That's a great way.
Because we said it's a guide.
Yeah.
So it's your GPS. So you should be following it. You should be looking at it. If you have a problem, you should be going to the code and reading it. You can take another route, but then if you ignore it, you might end up in the wrong forum.
As the court said, at your own peril.
Exactly. So I think that the message here is that employers need to do a health check. Businesses need to look at their current disciplinary policies. They need to look at their codes to see whether there is alignment with the code. And obviously we can assist with that.
Absolutely. Yeah. Well, that concludes today our webinar, ladies and gentlemen. I hope you enjoyed your time with us, and we really, really appreciate you spending some time with us. I see that there is a question in the Q&A box, Em. I'm just going to open that for us so that we can see. There's a question from Shelley Simon. How does the code regulate the process of overtime? Has the new amendment made new provisions?
No, it
doesn't even touch on it.
So your basic conditions of employment act would then apply. The provisions relating to overtime remain unchanged. This code only deals with dismissal. So it's all the elements of dismissal. Doesn't deal with any of the other obligations that you have as an employer.
Correct. Then we have a question from Anonymous. If a hearing is being held in a small employer by means of written representations, who would be the decision maker stroke chairperson? Remember, we had this debate. Yes. You and I are not on the same page.
Yeah. So look, do you want to?
No, you can. Over to you, because I might be outplayed on this one. But yeah.
Look, I think if the principle of you give them notice, they are allowed to make submissions in response, and then you have an independent person chair it. I think that would work. But if you have someone in your business, I mean, if it's a 5-man business, and the dispute is with the person in charge, it's going to be difficult for that person to make a decision.
Yeah, I mean, I'm more conservative than Em in that relationship. I would still suggest that one try and get someone who has no
external.
Yeah,
I think that's always the best.
It externally, but ideally someone who has no knowledge of.
But remember, that question is particularly in relation to small businesses, and small businesses don't have the resources, and this is the point of the new code.
Correct.
They have to be able to somehow deal with it internally.
It makes me very nervous, Em. Makes me very.
Well, I think there's going to be cases about it.
For sure.
I do think so.
Then we've got Onyi. How does the code define small business? How many employees? It doesn't. The code, I think it's deliberately left that open, and it's going to be on a case-by-case basis in terms of whether or not you will be able to define yourself as a small business. The factors, as we had already discussed in the code, are there, what is then taken into consideration. And then case law over time will also settle that. Potentially, the courts may also be, rely heavily on the 189A thresholds. They may even rely on the employment equity thresholds. They may even look towards SARS, because SARS obviously has its own definition in relation to a small business. So I think over time, and depending on the factors, each case will be dealt with on its own case-by-case basis, and we will then hopefully get over time some form of settlement in relation to what actually constitutes a small business. Is it turnover? What constitutes small turnover? If you're a 100 million rand business, however, you've got 20 employees, would you and I not consider that to be a large business? It is a large business.
But some employees with 20 employees have an HR person. So how would you define it? I think this is a wait and see approach. We're going to have to wait and see how the courts and our CCMA commissioners interpret this and take it from there. But I think you're right. I think that it has been deliberately silent on what would constitute a small business.
Then we have Johannes. Does the code make any contribution to a suspension, Em?
No.
Nothing.
No, because suspension is not dismissal yet.
That's it.
So
it's not dismissal.
The code deals with dismissal and all the different types of dismissal that you can get.
Then we've got Shelley, I think was, thank you. This webinar has generally broadened my understanding and will aid me in my administrative law module and upcoming thesis.
Thank you, Shelley.
We wish you all the best for that, Shelley. Then we've got from Kate, not much is said about imprisonment. What is your view on this? So practically, I've sat in a holding cell and I've given the person an opportunity, and we've convened and we've handed over the notification, and we've dealt with it. We've dealt with it on that basis. Not everyone is prepared, obviously, to drive through to Sun City or wherever one has to go. But again, one has to give that opportunity, or at least try to see if you can try and make contact with that person or get hold of their family for that matter, to try and then engage purpose of the dialogue to then close it off.
I think imprisonment is also tricky because the person is incapable of performing because they are incarcerated.
Correct.
So it is an incapacity to an extent, but I think that depending on what they were imprisoned for, there are also possible breaches of their employment terms.
Sure.
There's also possible bringing the company's name into disrepute.
Correct.
So again, it's going to have to be dealt with on its own merits. But I think it is definitely an incapacity. So my view on that is that it's in the right section of the code.
That's it. And you and I could debate this for the rest of the day, but I think everyone needs to get back to their jobs.
Yes.
Again, thank you, everyone. We will be sharing with you after this. We will be sharing with you a presentation that we have prepared, as well as just the quick reference guide to the code, which you will then have as an easy guide that you can just refer to. And our contact details, as well as our team's contact details, will be available. And should you need any help, please don't hesitate to contact us.
Yes, and if you have any other questions, we can't get to all the questions today. You'll see our email address is on the presentation that you will all receive. Feel free to just send us an email.
And I can't believe I'm saying this, but it's the middle of November. Happy holidays, Happy New Year. We wish you all the best for 2026, and we hope to see you soon. Thank you, everyone.
Thanks, everybody.
Bye.
Bye.